Good day, everyone. This is my final requirements in legal aspects in tourism and hospitality. This is Christine Acosta de Quito, Bachelor of Science in Hospitality Management, major in Hotel and Restaurant Administration from Wesleyan University, Philippines. So today I will discuss about the 5 legal codes that I picked, but before that, this video is intended for school purposes. So the legal codes that I will be discussing in this video are the RA 10911, the Anti-Age Discrimination Employment Act, the RA 4846, Cultural Properties Preservation and Protection Act, RA 9003, Ecological Solid Waste Management Act of 2000, RA 10586, Anti-Drunk and Drug Driving Act of 2013, and RA 7877, Sexual Harassment Act of 1995. Again, this video is intended for educational purposes. So let's start. In RA 10911, the Anti-Age Discrimination of Employees. Age may just be a number, but in reality, it can be determining factor for employment. It cannot be denied that preference may be given to youthful vigor in certain industry as opposed to elderly candidates who otherwise possess long experience. So on the other hand, employers would often prefer to place in positions of power for those who are more senior in these years than equally, if not more qualified, but younger candidates. So the employer has a prerogative and preference hiring employees, but the law ensures that an employee's right to equal opportunities is respected. So the Republic Act number 10911, or the Anti-Age Discrimination in Employment Act, is generally considered as unlawful act which consider age as a determining factor in hiring, compensation and benefits, separation, and other aspects of employment. So apparently, the law mirrors state policy to promote employment of individuals on the basis of their abilities, knowledge, skills, and qualifications rather than their age. So the law fronts upon arbitrary age limitations in employment in order to promote the right of all employees and workers regardless of age to be treated equally in terms of compensation, benefits, promotion, training, and other employment opportunities. So violations and anti-age discrimination law may come in form of underhanded methods calculated to encourage older workers to leave their jobs, such as reassignment, giving of unfair performance reviews, and withholding of reasonable workplace accommodations, or any other act with the goal of getting older employees to quit while being able to assert voluntariness of such action. So in such instances, the concept of constructive dismissal is relevant by way of analogy. So if you found guilty, the erring party may be punished with a fine ranging from 50,000 pesos to 500,000 pesos, or imprisonment of 3 months or 2 years, or both, at the discretion of the court. If the offense is committed by a corporation, trust firm, partnership or association of or other entity, the penalty shall be imposed upon the guilty officer or officers of such corporation, trust firm, partnership or association entity. The non-compliant companies may be reported to the nearest regional or provincial offices of the Department of Labor and Employment, where the discriminated employees may be given assistance in the filing of cases. So to support these legal codes, the example of this legal code is this article that published last December 2019. In this article, a 92-year-old grandmother, Lola Florerose Talastas, is hired as service crew in Legarda, Manila. So this article proves that the anti-age discrimination law is existing. To support this example, here's another article that published last February 2017. It says that age does not matter in employment. So DOLE issues rules on anti-age discrimination in employment. So it is to promote equal opportunities in employment for everyone. So Labor Secretary Silvestre H. Bello III has issued the implementing rules of the anti-age discrimination law. He said that the provisions of this order is to apply to all employers, publishers, labor contractors or subcontractors, and labor organizations whether or not registered. So he signed Department Order Number 170 or the Implementing Rules and Regulations of Republic Act 10911. So the next legal code is Republic Act 4846. This act shall be known as the Cultural Properties Preservation and Protection Act. In Section 2, it is hereby declared to the policy of the state to preserve and protect the important cultural properties and national cultural treasure of the nation and to safeguard their intrinsic value. So, we all know that in the Philippines, here in our country, there's a lot of national cultural treasure, and this legal code defining cultural properties and treasures that their preservation, restoration, and or reconstruction shall be under the supervision and control of the National Museum in collaboration with the Department of Tourism. In this regard, it shall be unlawful for any person to modify, alter, repair, or destroy the original features of any national shrine, monument, landmark, and other important historic edifices declared and classified by the National Historical Institute as such without the prior written permission from the chairman of said institute. In addition, all donations to the National Museum and Archives of the National Historical Institute, including the equivalent monetary value of works of art, manuscript, books, or other articles of cultural, historical, or scientific significance, are tax exempt and deductible from the taxable income of the donor. So the case scenario in this legal code is the San Agustin Payao Church in Ilocos Norte was affected by a great earthquake that took place on July 16, 1990. The earthquake greatly affected the structure of the church. How can the mayor of Payao secure funding for the restoration and reconstruction of San Agustin Payao Church in Ilocos Norte? What government agency can help him? So the mayor of Payao in Ilocos Norte may seek funding from the National Museum in collaboration of the Department of Tourism for the restoration and reconstruction of the Payao Church in Ilocos Norte. So the next legal code is the RA or Republic Act 9003 on June 26, 2001. RA number 9003, also known as the Ecological Solid Waste Management Act of 2000, was enacted to encourage industrial establishments through appropriate incentives other than to incentives to initiate, participate, and invest in integrated ecological solid waste management projects, to manufacture environment-friendly products, to introduce, develop, and adopt innovative processes that shall recycle and reuse materials, conserve raw materials and energy, reduce waste, prevent pollution, and to undertake community activities to promote and propagate effective solid waste management practices. So, under the same law, the segregation of waste shall primarily be conducted at the source to include household, institutional, industrial, commercial, and agricultural sources. So the example for this legal code is this article that published last February this year. So after the health pandemic, scientists have predicted that the world will face another one, the pandemic of waste. Last year, data revealed that the world produced 1.6 million tons of pandemic-related waste each day. So imagine the mountains of trash that may end up in landfills or waterways and directly affect the health and well-being of humans and the animals. So this Republic Act 9003 was signed into law on January 26, 2001. It is mandating the adoption of a systematic, comprehensive, and ecological solid waste management program in the country. So last February 2, 2022, the Department of Environment and Natural Resources, or DENR, marked the 21st year of the law's enactment through various events and advocacy projects. So the DENR Secretary Roy Simatu took it as one of his main priorities to improve the quality of our environment, particularly the air, water, and addressing solid waste issues. For solid waste management, he instructed the DENR to focus on two priority activities. First is the closure of dump site, and the second is the establishment of material recovery facilities, or the MRFS, in various LGUs. So the next legal code is the Republic Act 10586 or the Anti-Drunk and Drug Driving Act of 2013. So this Republic Act number 10586 penalized people driving under the influence of alcohol, dangerous drugs, and similar substances. It aims to protect citizens' lives and properties by promoting responsible and ethical driving. So you've most likely heard the phrase "don't drink and drive" already. So whether it's from public service announcement, driving instructors, or concerned parents and teachers, think that should be common sense. You'd be surprised about 25% of road accidents in the Philippines are caused by excessive alcohol consumption. So in the Philippines, the anti-drunk and drug driving law prohibits drunk drivers from going on the road. So in the Philippines, anti-drunk and drug driving law prohibits drunk drivers from going on the road. It's essential reading for all drivers, whether you're a new one determined to keep your record clean of any violations or an experienced one looking to refresh your knowledge. To summarize this Republic Act number 10586, it makes it illegal for anyone to drive a vehicle while under the influence of alcohol, dangerous drugs, or other similar substances. Alcohol pertains to wines, beers, or any other intoxicating distilled spirits, and the dangerous drugs are not limited to cannabis or marijuana, ecstasy, cocaine, or the shabu. So according to Soto, the law's author himself, the Anti-Drunk and Drug Driving Act of 2013 mandates a drug test for drivers involved in drug accidents. So also, the law enforcement officials can also pull drivers over if they believe the latter to be under the influence. Signs of driving under the influence include overspeeding, weaving, lane straddling, sudden stops, swerving, poor coordination, and the evident smell of alcohol on the driver's breath. So, to support this legal code, this news is published last August 26, 2022. So, it says or it explains about the law or about this Republic Act law. The last legal codes that I will be discussing in this video is the Republic Act 787 or the Sexual Harassment Act of 1995. Under RA 7877, work, education, or training-related sexual harassment is committed by an employer, employee, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any person who is having authority, influence, or moral ascendancy over another in a work or training or education environment, demands, requests, or otherwise requires any sexual favor from the other, regardless of whether the demand, request, or requirement for submission is accepted or not by the object of said act. So for the example for this legal code, this is one of the episodes in Ipaglaban Mo. So it shows the Republic Act 7877 works in this case. So, and that will be all. Again, this video is intended for educational purpose. Again, this is Christine Dacosta Diquito, Bachelor of Science in Hospitality Management, major in Hotel and Restaurant Administration. And this is my final requirement in legal aspects in tourism and hospitality. Thank you.